Well, hi, everyone, and welcome. My name is Ellen Bassett, and I am the chair of the Department of Urban and Environmental Planning in the School of Architecture here at the University of Virginia. I'm very excited to welcome our Lillian K. Stone Distinguished Lecturer this evening, Ms. Julia Olson, who is the Chief Legal Counsel amongst many other positions at our Children's Trust. Before I give a fuller introduction of the speaker, however, I'd like to take a minute to talk about the lectureship and the remarkable woman for whom it is named. The Lillian K. Stone Distinguished Lectureship was established to recognize outstanding leadership in environmental planning, policy, and law. It's a lectureship that is shared by the Department of Urban and Environmental Planning and the School of Architecture with the UVA School of Law. Nominees for this recognition must reflect the exemplary career and the life work of Lillian K. Stone, who, as an engineer and a longstanding employee of the U.S. Department of Interior, was responsible for compliance with an extremely important environmental law, namely the National Environmental Policy Act, or NEPA. So in this role for nearly 30 years, she worked tirelessly to ensure that the potential environmental impact of federal projects and proposals were adequately taken into account and mitigated. This is a pretty novel act. It's called a Policy Act, and it has helped to ensure that environmental considerations are counted and weighed in federal decision-making. This law has helped to safeguard our environment for those of us in the room today, as well as for future generations. Recipients for this lectureship are chosen based on their record of significant positive impacts in preserving and protecting the natural environment, and this reflects the spirit and the career of Lillian Stone. We want to extend a particular thanks tonight for two alumni who have made this award possible. The first is Thatcher A. Stone, who is the son of Lillian Stone, or a son of Lillian Stone, and an alumnus of the College of Arts and Sciences, as well as the UVA Law School. The second, Frank D. Kittredge, is a 1978 graduate of the School of Architecture. I believe that both of these gentlemen are in the audience with us tonight, and we're happy to see you here, if only remotely. So thank you again for this generous support. So I'm excited now to introduce Julia Olson of the Children's Trust. For a number of years, literally a number of years, I've been watching this legal case develop. And as many of my past students in the class called Law, Land, and the Environment know, I'm excited about the idea of the public trust doctrine being used a bit more widely. And I have given them pretty challenging readings written by Mary Wood of the University of Oregon as part of that class. So a special thanks to Timothy Beatley for responding to my nagging and successfully extending this invitation to Julia Olson. So just a few notes on Julia before she speaks. Julia graduated from the University of California, Hastings College of Law with a JD in 1997. For the first part of her 22-year career, she represented grassroots conservation organizations, which we all know are really important for keeping environmental law on track. And these organizations help to protect the environment, worked on organic agriculture, as well as human health. After becoming a mother and realizing the greatest threat to her children and children everywhere was climate change, she focused her work on representing young people and elevating their voices on the issues that will most determine their quality of life and certainly the well-being of all future generations. Julia founded our Children's Trust in 2010 to lead a strategic legal challenge on behalf of the world's youth against governments everywhere that are failing to address climate change. Julie leads Juliana versus the United States. This is a constitutional climate change case brought by 21 youth against the US government for violating their Fifth Amendment rights to life, liberty, property, and public trust resources. Julia and our Children's Trust are recipients of the Rose Walters Prize for Global Environmental Activism. She individually received the Kerry Rydberg Award for Environmental Activism in 2017, and she's also a member of the Rachel's Network Circle of Advisors, which all of you should know is in honor of Rachel Carson, another sort of female giant of environmentalism. So thanks very much. We were so excited to have her with us, or you with us, Julia. And I just want to say just a note on how we're going to manage this. For participants, we're going to use the Q&A function. So as she speaks and you have questions, please feel free to write those questions and they will be addressed toward the end of the talk. So without further ado, Julia.
Thank you so much, Professor Bassett, and I want to also thank Professor Beatley for also inviting me to speak with all of you, and to Dean Berman. and everyone at the University of Virginia Schools of Law and Architecture. And thanks to Frank and Thatcher for joining and for making this all possible in the first place. I know, I'm well aware that it is so much more powerful when we can come together in community physically with one another, but I'm grateful for the technology that allows us to do this in the meanwhile, and to be able to speak to you from the other side of the country. I'm in Eugene, Oregon right now. That's my hometown. And it is a beautiful fall evening. The leaves have changed on the trees and the rains are starting to set in. I also know that there are supporters in the audience tonight of our Children's Trust, and I just want to thank everybody. We would not be where we are today without the support of those in academia, from scholars and professors to students, and then all of the families, the elders and the children, and everyone who comes together to support this. So thank you. 10 years ago, when I founded our Children's Trust, neither the human rights community nor the environmental community really thought of climate crisis as a human rights issue. So when I went to human rights organizations to try to get them to partner with us, they said climate wasn't on their agenda. And when I went to environmentalists, they said that climate crisis had nothing to do with constitutional rights. And in a recent survey that was done about climate-related litigation around the world, at the time in 2010, there were only a small handful of cases that were really connecting the dots between climate crisis and human rights. But after 10 years of doing this work with young people, we have been able to show how climate crisis is in fact really harming children, our youngest generation especially. And that frame, that lens with which we view climate crisis, I think has fundamentally shifted, and the legal work being done has shifted along with it. So we're going to tonight talk about that vital constitutional conversation in terms of climate crisis and entrenched government systems that are causing it and violating the unalienable rights of the youngest among us. And so I hope after this evening together virtually that you will leave inspired and also with an expanded vision about the opportunity in front of us, and also with purpose for challenging the way we live today and sort of this daunting crisis that we face. I want to lead off with a quote from US Supreme Court Chief Justice John Roberts. He said, "There is no better gift a society can give children than the opportunity to grow up safe and free, the chance to pursue whatever dreams they may have." And I think that's really accurate. And if we were to measure all of our policies and government conduct by that standard, we would have long ago put an end to our dependency on fossil fuels. All right, so I'm going to share my screen. Just one moment. Show you some slides so you don't have to stare at me during this whole talk. All right. Let's see. There we go. So this is one of our plaintiffs in the Juliana litigation, which I will talk about this evening. His name is Aji. And for some reason, I'm having trouble changing these. All right, here we go. So at our Children's Trust, we operate under 3 core principles. First of all, we are the only law firm in the world that is dedicated exclusively to representing children and youth on the climate crisis. And so our core principles are that we elevate the voices of young people and future generations for climate rights. We advocate only for science-based and legally enforceable systemic remedies in court and against government. And we use fundamental human rights as the basis for our actions. We launched our strategic legal campaign on Mother's Day in 2011, and we had legal actions in all 50 states and against the federal government, as well as global cases. And at the time, we were partnering with a youth organization called Kids versus Global Warming. And they helped to organize marches all around the world in over 100 countries, so that young people were marching in the streets at the same time all of these legal actions were being filed. And from the beginning of this work in 2011, people have often asked us, well, why children? Why are youth the ones to do this? And the answer really, I think, is to look back in history in part. There is such a long, long history of young people leading some of the greatest social movements towards justice and safety and equality. And this is an image from 1903 when children marched with Mother Jones from Philadelphia to New York, protesting child labor in textile mills and the dangerous conditions there. And then in 1955, Claudette Colvin, at 15 years old, refused to give up her seat on a bus. And she was arrested and went to jail and became one of the plaintiffs in Browder versus Gale, a Supreme Court case which legally ended racial segregation on public transportation in the state of Alabama. And then I know you're all familiar with the Children's Crusade in 1963. Again, this was led by Charles Avery, a high school student who gathered 800 fellow students for that famous walk, that 10-mile walk to Birmingham. And it was really their bravery and determination that turned public tide in support of the civil rights movement. And then more recently, I mean, we see this, on a monthly basis now, where young people in different movements are rising up, from the Dreamers and the DACA movement to March for Our Lives, protesting gun violence, the Sunrise Movement on climate, and of course the Black Lives Matter movement. Youth are just rising up again and again to create a more just and a safe world to live in. And they're seeking to really end all kinds of systemic injustices, from racism and white supremacy, to sexism and patriarchy, to violence against children and communities of color and indigenous peoples. And they seek to end the climate crisis. So this is why young people, they have always made these unflinching demands on society to force society to really value their safety, their security, and their equality. And I think if we pay attention to them, we will do right and be on the right side of history. I also want to share another story. This woman, Paulie Murray, is someone I have a particular fondness for. She's been enormously inspiring in my work. And for me, her story is really a central part of the civil rights movement that we turn to in our work in the courts. So, oops, we'll just leave it there for a second. So Paulie Murray was in 1944 a young woman in law school at Howard University, and she was not only the only woman, but she was #1 in her class. And one day she was in her constitutional law class, and she was arguing that the work that the civil rights movement was doing and that the NAACP was doing to try to basically deal with Plessy versus Ferguson, which said that legalized, that government sanctioned racism was legal. And they were trying to challenge the equal public facilities, to say that they weren't equal and they weren't providing equal services to Black Americans as to white. And Paulie Murray said, we should really be challenging the separate provision in Plessy and argue that separate is unconstitutional. And so she made her argument. She bet her professor $10 that within 25 years, Plessy would be overturned as unconstitutional, and she wrote a paper on it. And basically, all of the men in the class laughed at her. And what is truly inspiring is that that law professor went on to co-counsel Brown versus Board of Education with Thurgood Marshall and win Brown versus Board of Education in 1954, only 10 years after Paulie Murray had basically developed the theory that would then be argued in Brown. So there we go. There's Brown versus Board. So all it took was an inspired and creative law student to really make an argument that has changed the course of history. So tonight I'll focus most of the talk on Juliana versus the United States. And this case is one of the most known, it's gotten the most publicity, but the story of this case is a similar story to many of the other cases that we are involved in around the country and globally. And, you know, the really important questions that are posed in the Juliana litigation are about the unalienable rights of young people, their rights to life, their rights to liberty, and those liberties include their right to personal security and to protect their family autonomy and their culture, their rights to equal protection of the law as children, and their rights to public trust resources, which include our air, our water, our ocean, the shores of our seas, all those things that are essential to human life. So as I walk through this case, keep in mind that this is a case about children's rights. It's not just an environmental case. It's not just a typical civil rights case. It does merge these concepts of children's rights and climate rights into this Fifth Amendment case. So we filed originally against the Obama administration, and the first big decisions in the case came in 2016. We had two opinions from two different judges. But the key was in November 2016, 2 days after President Trump had been elected to office, Judge Aiken wrote in an opinion allowing the case to proceed that she had no doubt that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. And this was a groundbreaking ruling. It was the first time any judge anywhere, as far as I know, had said these words and really expressed the climate right as a fundamental right. Oops, change. There we go. In doing so, what Judge Aiken looked at was whether the complaint that the youth had brought had alleged that government action was affirmatively and substantially damaging the climate system. And she found that it had, and that what the children had argued is that this ongoing systemic conduct would cause human deaths, shorten human lifespans, and result in widespread damage to property, food sources, and ultimately the planet's ecosystem. So she said to the 21 plaintiffs, my clients, you can go to trial. And so we prepared for trial. And in a series of twists and turns that are very complex procedurally and legally, but they include 4 petitions for writs of mandamus that took us up in sort of early attempts to get an appeal at the Ninth Circuit Court of Appeals. The Trump administration made 2 attempts to stop the case at the US Supreme Court. We won all of those 4 attempts at petitions for mandamus. We won the 2 battles to stop the case at the US Supreme Court. But ultimately, the youth ended up in front of the Ninth Circuit once again on what's called an interlocutory appeal. And in this interlocutory appeal, there are sort of key questions that the Ninth Circuit was asking. The first was, can these children go to court at all? Do they have standing to bring the case? And the second question was, does the court have a duty to do anything? Can it do anything, but must it do anything? And the third question that wasn't directly asked in the case, but I think is the central question, and it goes to this issue of separation of powers between our three branches of government. And the question is, does the political majority in power in government get to decide what happens to our climate system, whether to destroy it, whether to protect it? Do those decisions go unchecked by the third branch of government? And so the Ninth Circuit was reviewing these issues, and the legal words for all of these are standing, Article 3 standing, separation of powers, and whether the children could bring their claims directly under the Constitution. So after an oral argument in June of 2019, we received a decision in January of this year. And the decision came down, it was a divided decision. 2 judges in the majority ruled against the youth, and then 1 judge dissented, in a powerful dissent that I highly encourage everyone to read. And so what I'm going to do is just walk through the different elements of the decision, because I think it really beautifully tells the story of the case. So the majority began, and so I'm first going to go over all the areas of agreement between the judges. So first of all, the majority said that there's a substantial evidentiary record that documents that the federal government has long promoted fossil fuel use, despite knowing that it can cause catastrophic climate change, and that failure to change existing policy may hasten an environmental apocalypse. Consistent with this graphic from NASA, the majority found that carbon dioxide levels had skyrocketed, especially during the last 40 years, and that the evidence demonstrated that our federal government was a substantial factor in creating those levels. The majority wrote that copious expert evidence established that that unprecedented rise stemmed from fossil fuel combustion, and that it will wreak havoc on Earth's climate if unchecked. The majority also found that this extreme heat from these excess levels of carbon dioxide were melting the polar ice caps. The court found, based on the evidence in front of it, that the seas could rise between 15 and 30 feet by 2100. And much of the evidence in the case that the court was looking at was government evidence. And then, after sort of detailing the real dangers with climate crisis and our continued reliance on fossils for energy, the court walked through the undisputed evidence that existed with respect to the plaintiffs and how they were being individually harmed by the government conduct. So on this question of standing, the majority opinion found that the children's injuries included exacerbated medical conditions, damage to property, and psychological harm. They said that the problem is approaching the point of no return. Absent some action, this climate crisis will bury cities, spawn life-threatening natural disasters, etc. And in fact, this summer, after this January decision, we saw some of these life-threatening disasters occur out in the West. This is my plaintiff, my client Alex, on his farm in Southern Oregon. This was in September when the Western fires were raging. And we were all wearing respirators just to go outside because we had the worst air quality in the entire world for weeks. This is Isaac and Tia. two of our other plaintiffs, and they both suffer from asthma. And Isaac has been told that his asthmatic condition is worsening with the increased incidence of wildfires and hazardous smoke in the West. So the majority went on to then describe what the United States is doing to contribute to this crisis, and found that our country is expanding oil and gas extraction 4 times faster than any nation. The dissenting judge agreed with all of this consensus and said that this existential threat was actively backed by the federal government. So, when we were building the evidentiary record for this case, we went to every presidential library since Kennedy. We just dove into government records to really figure out what had been going on. And the story became really clear that despite decades and decades of government scientists warning about this danger, the conduct coming out of our government was as if they didn't know anything, right? And so this graphic shows you that over every administration, whether it was a Democrat in office or a Republican, that the energy policy of our government was to continue to extract and burn fossil fuels, such that about 80% of our energy use is still fossil today. Some of this evidence, just a few snippets, and there are thousands and thousands of pages in the record, but some of the earliest, strongest warnings began in 1965 under the Lyndon B. Johnson administration, where there was an entire book and a report on pollution and a whole chapter on basically climate change and the warnings about what would happen by the year 2000 if we continue to put more carbon dioxide in the atmosphere. And then by Nixon's administration, his advisors were really concerned about sea level rise. They were projecting that we would lose New York City and Washington, DC. They were saying that the federal government must play a leadership role in solving the problem, and that if we continued to burn fossil fuels, it would melt the polar ice caps and inundate the coastal regions of the world. So this was around the time I was born that our government was saying these things. And nonetheless, the energy system, which includes, not just electricity, but transportation and industry, processing, generation facilities, all of that continues to be promoted based on fossil fuels. Our government has said over and over, it is firmly committed to that pathway. All right, I'm gonna pause here before I go on to tell you the next part of the court decision, where we see the disagreement happening between the majority and the dissent. And I'm just going to show you a brief little teaser clip about a documentary film that has just been released. It's having its world premiere at the Doc NYC Film Festival right now. And you can actually watch it, and go to the website and buy a ticket and watch it for 2 more days. So I really encourage you to do that. An award-winning filmmaker, Christy Cooper, basically spent the last 5 years tracking the Juliana case, visiting the plaintiffs, really following what was happening in the court. And it's really a remarkable film. So I'm going to show you just a clip so you can see some of our plaintiffs. Let me stop sharing that. Okay, here we go.
This is my all-time favorite place to go. When I was scared because there was the hurricane, I came up here, and this is where I felt safe. It's because I knew if it flooded that it couldn't wreck anything here or everything. So I knew that. did trust this area right here. Crap, this is new. It's very frightening and disturbing. I see this giant tree down in one of my best friend's yard. I've lived with the hurricanes my whole entire life. And even though it's reality, it's really scary.
All of our traditions and everything is based here. And a lot of our origin stories are from here. We can't just leave because it's too sacred for us.
It's all been a matter of choices. And our feelings of despair and dread and anxiety is all because of choices that we had no participation in.
Everything could have changed, like really before I was born. I was born in 71.
I think 1971 will be known as the year of action for the future generations of America.
The history of this whole period has got to be the saddest story ever told. This huge failure to rise to the moment. I think it's the greatest dereliction of civic responsibility in the history of the Republic.
When I look back over that period of time, I think in some sense I failed to accomplish what I wanted to accomplish. I'm very gratified that somebody can make use of my documents.
This is why we need trial, because the story has to come out. And government can come in and make their case if they want, but a judge needs to hear from both sides. Because if it's as bad as we think it is and all the evidence we have indicates, it's the biggest crime against humanity ever. And it's a constitutional violation by any standard. All right, so that's just a little sneak peek at the film. And Gus Speth, who you saw there, headed CEQ during the Carter administration, and both Gus and Nikki, who you saw, were just a tremendous source of information and the evidence and the expert work that we were able to gather in the case to build the case in preparation for trial. Go back here again. All right. So some of the youth you saw there included Levi, who lives in Florida, who lives on a barrier island that is threatened, and Jamie, who is Dine from the Navajo reservation and is really losing her way of life and culture from the consequences of climate crisis, including the severe drought conditions. So faced with all of this evidence, the evidence of harm to the climate system and to the plaintiffs, and then the government knowledge, that long-standing deep knowledge of what would happen if they continued down this pathway, and the abundant evidence that notwithstanding that science and information, our government continued to support and permit and subsidize and promote fossil fuel energy. That was all undisputed. And the majority and the dissent in the Ninth Circuit both agreed with that information, found there was sufficient evidence in the record to prove up those facts. So where they disagreed was only as to whether an Article 3 court can provide their requested redress. So, and I'll just read this. I love this line from the dissent before I kind of go into more of the details of the remedy. But Judge Staten wrote, seeking to quash this suit, the government bluntly insists that it has the absolute and unreviewable power to destroy the nation. My colleagues throw up their hands, concluding that this case presents nothing fit for the judiciary. Instead, the majority said the children's impressive case for redress must be presented to the political branches of government or to the electorate at large through the ballot box. The dissent responded by saying that fundamental rights may not be submitted to vote. They depend on the outcome of no elections. They are beyond the reach of majorities and officials. And we hear this a lot from certain judges in certain courts, that children who are being harmed by climate crisis, who can prove up that their governments have a big role to play in causing that harm, that they should go vote. And I represent a lot of young people who are under the age of 18, and telling young people to go vote is a bit of a slap in the face when you don't have those suffrage rights. And I think it really illustrates how much the judges who are saying that are not paying attention to the fact that these are cases about children. And no matter how large or complex the problem may be, or how entrenched our government system is in fossil fuels, that does not put it outside the reach of the courts. And the political majority, which for over 50 years has chosen this course of action, finally does need a check by the courts. So going to remedy, a remedy in a constitutional case is often complex, but there are some parts of remedies that are pretty straightforward. So the first thing the court can do is it can declare the children's rights, and it can create a standard for our climate system and for protecting it. The second thing it can do is it can order a remedial plan. The third thing it can do is it can enjoin government conduct that is making climate crisis worse. Like, for instance, allowing fossil fuel extraction from federal public lands. President-elect Biden, when he takes office on January 20th, his administration could decide to do what the two prior administrations who were defendants in the case did not, and that is to engage in settlement talks with the plaintiffs and change the legal position that the administration takes. So again, this is the core issue, is the majority says an Article 3 court can't do anything. The dissent says, actually, we can, and there's a lot of history that shows that we can. So just pointing to some of the systemic government problems that have been resolved in part by the courts, or at least where courts have weighed in, include segregation, right? Desegregating schools and other institutions like public housing, the treaty rights litigation that happened in the Pacific Northwest to protect the tribe's rights to adequate salmon, the California prison litigation and other prison litigation around the country. These really complex issues where courts weigh in with constitutional standards and then direct government to go and fix it, develop a plan, tell us how you're going to bring your system into constitutional compliance. And for the lawyers or the legal community in the audience, when we look back at Brown versus Board in 1954, that original opinion was only a declaration of law. It didn't tell the schools to do anything in particular. It just merely said that segregation in public education is not constitutional, and Plessy versus Ferguson is overturned. And that was transformative. And it wasn't until a year later, in 1955, when the Supreme Court actually directed the lower courts to administer the remedies and required the schools to submit plans for desegregation that were then monitored and overseen by courts. Some of those court orders are still being overseen today. Some I think are nearly 50 years old at this point. And the core, issue for us and for the dissent is that, again, it does not matter how complex or how big the government conduct is that is causing the constitutional deprivation, that there's no exception to justiciability when our individual liberties are at stake. So those were a lot of words. So here's a little break with just a simple image I like to show. 50 years ago, I wouldn't be here today doing this Zoom talk with all of you, right? And the way our computers have evolved and we have these smartphones now is just the technology evolving. But the way we produce energy has been really stuck in this old fossil way of producing energy. And there are a lot of reasons for that. And our government has been a really large player in entrenching those systems. So I want to move just briefly to the scientific component of the remedy, because one of our principles at our Children's Trust is that we trust scientists. We listen to scientists, and we think that they have a really important role to play in establishing what a remedy looks like. And so when we're thinking about a legal standard for protecting the climate system and protecting fundamental human rights, we need a standard for atmospheric carbon dioxide that doesn't endanger people. And what the scientists say is that to protect our oceans and our marine life and to bring our Earth back into energy balance, we really need to reduce carbon dioxide levels from, they're about 412 parts per million today to 350 by the end of the century. And so those are the scientific standards that we are working with. And you will see other numbers, sometimes in law, some in the Paris Agreement. And so I just want to be clear that it is what our scientists say and our experts say, is that to really protect the opportunity of children to have fully secured human rights in the face of climate crisis, we can't set a standard of 400 parts per million or 450 parts per million of CO2. And we can't set targets of allowing heating of 1.5 or 2 degrees Celsius. We really need big reductions, and we need to go back. And the good news, the really positive news, is our experts on the solution side, the energy system design side, they say that this is really feasible with existing technology and emergent technology, as well as cost effective. So this graph right here, this is for Florida specifically, but the story is very similar when you look at the United States as a whole. I just didn't have the exact graphic for that to show you. But basically, energy experts have modeled different transitions from a fossil energy system to a clean energy system, one that doesn't cause climate crisis. And what they see across the board is any which way you do it, you end up with basically lower energy costs than we've had historically. And what you can see in this graphic is that the fluctuations of energy prices really level out, because you don't have the kinds of fluctuations that you would have when we have oil crises, for example. So just summing up the Ninth Circuit opinion, I think this is one of the key messages the dissent Judge Staten leaves us with. And that is, faced with all of these catastrophic harms and the worsening of them, why people in the future will ask, why did so many do so little? And she's really posing that question, I think, to judges everywhere, and really to the world at large. So after this decision came down in March of this year, we petitioned the Ninth Circuit for what's called an en banc rehearing. And if we win that petition, we will then go before 11 judges who sit on the Ninth Circuit, and we will re-argue these issues and ask them to reverse the panel majority and basically adopt the analysis of the dissenting opinion. So we are still waiting for that. Meanwhile, we have a new president-elect, and instead of having a climate denier sit in the White House, we will have a climate believer come January. And so we are, posing the question and hoping that Biden-Harris administration will want to come to the table to engage in settlement discussions with the Juliana plaintiffs. The other thing that a new administration can do is it can reverse the legal position, the really unsupported legal position that the Trump administration took over the last 4 years on the issues of standing and separation of powers. A Biden-Harris defense of the case can come in and say, yes, children do have standing when they are being harmed by their government. And under the separation of powers, the courts have a really vital role to play on questions about Fifth Amendment rights to life and liberty, and reviewing government conduct. So we will see what happens, but there's a lot of exciting possibilities coming up in the next several months. So meanwhile, and just the last few minutes of my talk, I wanted to highlight some of our other work outside of the Juliana case. We have 6 actions going around the United States with others in the works. We're waiting for a Supreme Court decision from the state of Alaska, really big decision there that we're hoping to see by the year's end. We are waiting for a decision from the Washington Court of Appeals on a case against the Washington government, and had a really fabulous oral argument a couple months ago in that case. That's on our website if anyone wants to watch it. And we have a Montana case. There are all our amazing plaintiffs in Montana. And that case is in its early stages. It's in the trial court, and there will be an argument on a government motion in that case, asking that the case be dismissed. And Montana has one of the strongest public trust rights embedded in its constitution. And so we're really excited about that case going forward. And our Florida case is up before the Court of Appeals in Florida. Somewhat similarly to the Juliana case, the lower court said, there's nothing I can do, throw up his hands. And so we are appealing that decision and have a great team down there working on that case. We've been in front of the Colorado Oil and Gas Conservation Commission for the last several months, making progress with addressing the fracking going on in Colorado. And we're actually, for over a year now, we've been in conversations with Virginia youth who sought us out and asked if we would help them find legal representation to bring a case in the state of Virginia. And your constitution, under Article 11, is one of the few constitutions in the world that has codified that your Commonwealth's policy is to protect the atmosphere, lands, and waters from pollution, impairment, or destruction for the benefit, enjoyment, and general welfare of the people of the Commonwealth. And this is really a codification of that public trust responsibility that governments have to protect resources. And I believe this was a 1971 amendment. Someone can correct me if I am wrong about that. But to actually list the atmosphere is really an amazing thing. And if anyone wants to learn more about our work in Virginia with youth of your state, you can contact Nate, our senior staff attorney, ourchildrenstrust.org. So expanding out a little bit from the state level, these are global actions from countries all over the world. Most of these cases you see here are youth-led. Some are on behalf of a broader group of citizens. And these are just the kinds of rights-based, human rights-based climate cases that we're seeing all over the world. We have inspired or helped lead many of these cases and are supporting many of them. And I'll just highlight a couple. So we have an amazing group of Canadian plaintiffs suing their federal government in the La Rose versus Her Majesty the Queen case. They just got an adverse decision that they're appealing. And there are actually 3 youth-led climate litigation, climate cases in Canada to protect the constitutional rights of youth. These are our Mexican plaintiffs in a case that will hopefully go to oral argument on the merits in the spring or late winter. And these are plaintiffs in our Uganda case that we've actually been supporting for almost our entire time we've been around as an organization. And they were one of the early global cases that was filed. And they go to hearing this month in Kampala in the High Court, and will be presenting expert testimony. So we're really excited about that case finally moving forward. And then another case just to mention is a Norway constitutional case against Arctic oil drilling that the Norwegian government continues to permit. And young people just had an amazing 7 days of hearing before the Supreme Court of Norway. All of the justices, I believe it's 16 justices, sat to hear argument and evidence in that case. And they did so, the entire court sat for a week because they recognized the importance of the matter. So we don't have a decision there yet, but hopefully we'll see something positive come out of the Norwegian court. All right, so as I get to the end here, I wanted to take you back in time a little bit to James Madison, the drafter of the Fifth Amendment, and of course, our 4th president. In 1818, James Madison was speaking in front of a group of farmers, an agricultural society, and said that the atmosphere is the breath of life. Deprived of it, we all perish, man, plants, animals. And I raise this because when we're looking at fundamental rights, particularly here in the United States, we go back to our history and we look at, in part, what did the founders mean in the Constitution? What did they intend for it to be? What kind of system did they want to create? And I'll just remind everyone, and you all are deeply tied to this because of your history in Virginia, but the founders were farmers and they were deeply connected to the land. And many of them kept weather journals. They understood about the climate. They understood that humans could affect the composition of gases in the atmosphere. They were learning from Alexander von Humboldt about deforestation. They knew that our dependency on these systems of air and water and soil health were vital to the nation and to the wealth of the nation and to the future of the nation. And so to the extent we want to look at the Constitution through that lens of what it meant in the beginning, there's really adequate, abundant support that the founders of our nation would have wanted us to protect the atmosphere and the climate, to secure the blessings of liberty to ourselves and to our posterity. That was why they ordained and established the Constitution. So I wanted to point out that there is this amazing author and really activist Roman Krasnarek, who wrote this book, The Good Ancestor. I think it's available now to purchase. And he tells stories of movements happening around the world that are bringing into focus this idea of what it means to be a good ancestor and to think long-term versus short-term. And I really highly encourage you to check out this book. He tells stories for the architects in the room. He brings in stories about communities that are really looking at how to design with cathedral thinking in mind, how to create sustainable design to in part address the climate crisis. And this comes from the Future Generations Commissioners in Wales. And I put the website there so you can check them out. But there's just a lot of amazing ideas being not only generated, but implemented around the world. There's some designers in Japan that are doing some awesome work as well. So I just wanted to point that out to you. And I'm gonna just close with this, and then I look forward to questions. I think our youth plaintiffs always say these things best. And so whenever I can bring in their voices, I really like to. This is Shatesca Martinez.
My name is Shatesca. I'm 16 and I've been at the front lines of the struggle for a while now. And And it inspires me so much to stand here with these 20 other youth plaintiffs. And every plaintiff has a story. And every plaintiff has a way in which they're going to be impacted by climate change, or already have been impacted by a global problem created by past generations. And this is not easy work. To take time out of our lives to come and do this, thank you to each and every one of you, to each and every adult who has helped sacrifice to make this happen today. We are making history. And we are standing here today to fight and protect everything that we love, from our land to our waters, to the mountains, to the rivers and forests, to fight for our family, for future generations, for our children, for the planet that we will leave them. We stand here today changing history because this is the moment where we decide what kind of legacy we are going to leave behind to future generations. And we're not heroes, and we're not any different than any other young people on the planet. We have the amazing ability to be able to come together like this. And we're fighting for the futures of every young person in the crowd today, of every young person in the world today. That's what we are standing to protect. And this cause, we will not back down. We will not be silenced. We will not allow multi-billion-dollar industries to silence our voices. We will not allow the federal government to silence our voices. We will continue to stand in our courts, in our streets, and on the front lines of fossil fuel infrastructure until every pipeline has been shut down, until we force the federal government to put in place climate recovery plans to ensure a healthy, just, sustainable planet for our generation and those to follow. Thank you.
All right, thank you, everybody.
All right, wow, thank you so much. We appreciate that. So we have some time left, which is wonderful, for some Q&A. And there are already 2 questions in the question and answer box. So for those of you who are watching, I've also checked out the participant list, and so I'm really pleased to see a lot of my students are here. Feel free to throw in some questions for Julia. We'd really like to engage in a conversation here. So I'm going to start with a question that was posed by John Cannon, who you may know, who's with our law school. And so John Cannon has written, "Thank you so much for joining us and sharing this inspiring story. Expanding on your earlier thoughts about remedies, what would be the content of an acceptable remedial plan or settlement in the Juliana case? Or would that content be determined in later phases of the litigation? And if so, how do you visualize the steps by which acceptable progress would be made?"
Yeah. So, one thing about constitutional remedies is the first step, again, is for the court to declare that there's been a violation of a constitutional right, and to express that. And oftentimes there's a standard established, right? So in Brown versus Board, it was segregation is now unconstitutional. So you have to desegregate. And in the first instance, what courts will do is they will allow the government defendants an opportunity to prepare a plan, or basically say, this is how we're going to bring our system into constitutional compliance. And so while we have ideas about what we would love to see in a plan, and we've worked with experts who are developing model plans and pathways for governments to use, we're not in the business of trying to dictate the specific policies that would be in a climate recovery plan, for example. And nor would we ask the court to dictate those policies, right? So I think it's really incumbent on the government defendants to come up with the policy-based solutions, and for the public at large and for experts in these fields to contribute and weigh in on that process. What we would ask the court to do if we got to that stage of a court ordering a plan or particular emission reductions, we would want those there to be benchmarks and timelines for achieving those emission reductions in accordance with what the scientists say is necessary to protect the rights. And so our hope would be that the government would prepare a plan, they'd submit it to the court would sign off, emission reductions would begin going down, and the government would report back to the court on the status of its progress in achieving those benchmark emission reductions. And if it missed a mark, it would have to go back to the drawing board to figure out what to do better to hit it the next time, or make up for what it missed. So we're really looking at the high level standard, the emission reductions that need to be achieved. The details of the policies and the pathways government chooses is going to be up to it. And I think that relates to Thatcher's question as well about nuclear power. So I have personal feelings about nuclear energy. My personal feelings are that until we get to safer next generation nuclear technology, that I don't think that nuclear is the answer based upon the experts that we work with, what they're telling us, the energy experts. What our energy experts say is that right now they would have the government maintain the existing nuclear fleet until its natural life ends, but not invest in new nuclear, at least in the United States, and that we can actually more cheaply transition off of fossil fuels with renewables because the costs have gone down so significantly, and nuclear energy is still very, very costly. But there are other experts who believe that nuclear is an important part of the conversation. And that's not my area of expertise. I have personal feelings about it, but I think energy experts need to be the ones to decide what makes the most sense in different countries.
Okay, great. So that was the answer to Thatcher Stone's question about nuclear power. Tim Dodson would be interested to know how you identify or find the plaintiffs for the cases with which you're involved.
Mm-hmm. Yeah, so I mean, at this point, a lot of young people contact us to get involved and to bring cases, but we also work with youth organizations and partners who put the word out. For example, Earth Guardians, which is a named plaintiff in the Juliana litigation, is Shatascott Martinez's organization, and they have youth crews all over the country and globally. So they put the word out when there's a new case in the works. And mostly it spreads by word of mouth. You know, young people have networks and our partnering organizations have networks. And so people put the call out and interested young people come in. And then there's a pretty, significant process of really having conversations and interviews with young people to see who has real climate harms that they are able to identify, that we can bring in evidence to support. And this can be a long journey. And so making sure that the young person really wants to take this on and that they will have familial support to do it.
All right, terrific. So a question from Elizabeth Roosh, I hope I said that correctly. If the Biden administration agreed to settle, what role or say would Congress play in the settlement?
So this case, the Juliana case, it's against the United States, but we have to name specific agencies and officials who are part of the illegal conduct that we're challenging. And so, it includes the Departments of Energy and Interior, Agriculture, EPA, the big ones. And this settlement would not require Congress to do anything. Congress wouldn't be part of the settlement agreement. It would be the executive branch agencies and officials. And they would also be the ones to then carry out the terms of the settlement agreement. And really, one of the issues in the climate crisis and with energy policy is that Congress has actually granted the executive branch a tremendous amount of authority through statutory law and said, you control our air, you control these systems, you control our federal public lands and how much fuels we allow to be extracted. And so there's abundant authority on the executive side to really deal with most of the issues that are causing the crisis that we allege in the case. So we don't need Congress. Now, Congress can always step in and enact legislation that would override certain things or deal with the constitutional infringement. Congress can do that at any point, but our work is focused predominantly on the executive.
So a question from Harrison Ryan. Are there legal actions that can delay President Trump, selling the Arctic and any other executive orders that he does to sabotage the environment in his last few weeks in office? And are there any such objections in court already that would delay these actions until Biden is in office?
Yeah, I think these last minute things that will happen, I wouldn't worry too much about them. There are a lot of awesome lawyers in the environmental law community who will be watching these actions and filing suits to challenge them as soon as something becomes a final decision. And we'll see how much the current president can actually accomplish as a final order before he leaves office. There are, as Ellen mentioned in the beginning, the National Environmental Policy Act and other laws require the government to jump through hoops in order to make final decisions. And so something like an executive order can be undone very quickly by President Biden, and other actions may take a while. And those that get through, I know, will have legal challenges and can always be reversed. And that's the thing. And if I can just add, Ellen,
sure.
That's that process, right? Of one president coming in and doing one thing and then leaving, and another president coming in and doing something else. When you have constitutional rights at stake and you have a court order that is binding government in a particular way, then you don't have these changes in political winds about whether we will protect the climate system or not. And it's really important, right? It's like thinking about segregation. If one administration could come in and say, oh, we're going to segregate again, which some might like to, that would be unconstitutional. And we need that kind of the power of the court to say that this continuation of perpetuating fossil fuels at the expense of the lives of young people is now unconstitutional, rises to the level of a constitutional violation.
Great. My class had to spend some time looking at all the executive orders that Trump has signed in the last few years. So it's probably first and foremost in their mind. Also, I think today's Washington Post or the New York Times talked about trying to sign contracts for doing aggressive drilling in the Arctic. So that's probably in front of mind. Another question, this is from Trevor Storm. Thank you for taking the time out of your day to be here. I was just curious how moving forward, on standing, how would standing in relation to the plaintiffs be considered? This is what you raised about their age and that kind of issue.
Yeah. So standing has, thanks, Trevor, for your question. Standing has three components. One is showing that you've been injured in some way by the defendants, that they have caused it. It doesn't have to be direct cause, but at least there's a chain of causation. And then the injury can be redressed, at least in part. And so any plaintiff needs to really demonstrate some sort of harm that they're experiencing. And not just future harm, like in 50 years this will happen, but it's nice to have really concrete harm that has happened already and that is imminent and that will worsen. That's what we're looking for in plaintiffs. The causation piece, we have really built up already about these chains of causation that are causing the harm. It's really clear with issues related to sea level rise, the wildfires that I talked about in the West. The fire season in Oregon in the 1970s was about 23 days. It's now well over 100 days, and the fires are hotter and they burn more acres, right? And the air pollution is awful. So you can directly correlate these things with the climate crisis and with the levels of carbon dioxide in the atmosphere. So we look for that kind of correlation. And then the third part, which is the redressability part, Congress has said through the Declaratory Judgment Act that if you have injury and you have causation, courts can declare whether your rights have been violated. And that is in part your redressability. And then the planning that we talked about would be the other form of redress, really ordering the government to develop plans and correct this violation.
Great, thank you so much. So a question from Dominic Givaniello. How important is the feasibility of alternatives, for instance, the cost of renewable energy, in building a legal case for decarbonization?
I think it is, from a messaging perspective, an important factor, but I don't think it's a legal factor in a constitutional case. So we bring in the evidence about cost of the energy systems because it's an important part of the story, and it's a part of the story that favors us. But I don't think it's a component that would determine whether the government is violating people's rights and whether there is a remedy. And so one thing about cost that a lot of people misunderstand, and even our politicians, I think, don't talk about in an accurate way when they talk about decarbonization, is, I'm sure you've all heard, even in the presidential debates, all of these really big numbers, like we're going to spend trillions of dollars, right? The Bernie Sanders campaign was accused of like wanting to spend $15 trillion or whatever the big number was to move us off of fossil fuels. And so what's really important when we're talking about cost is that we distinguish between gross cost of an energy system versus cost to consumers. And those big, huge numbers, those trillions of dollars, that's the cost of the entire energy system. And we spend trillions of dollars on fossil fuel energy. So we're going to spend trillions of dollars on energy. It's just a question of which kind of energy we want to pay for. And what all of our experts say is that you will not spend more on clean energy than you spend on fossil energy. And when I talk about energy, I'm talking about not just electricity in your home, but the products you buy, your transportation system. All of these things are part of the energy system, and it is cost effective today to power our nation on clean energy. More cost effective over the long term than fossil energy. And that does not take into account the cost savings of not having climate disasters or the health consequences. So when they do that economic analysis, they're not dealing with climate benefits of transitioning. They're just looking purely at the cost of the system itself. So when you factor those in, it's a no-brainer.
So I'm going to ask a couple questions while other people dream theirs up. I lived and worked in Uganda for a little under 5 years. And so I know that the Ugandan constitution, like a lot of the sub-Saharan, more recent constitutions formulated in sub-Saharan Africa, generally have a right to a clean environment built into the constitution itself. And so I'm curious, relative to the, I think it was Mbabazi case that you're having against NEMA, the National Environmental Management Authority. How are you framing that case? And do you see a different sort of argument taking place in a developing country than you see in a place like the United States? And what comes to mind, of course, is that in the United States, we are far more responsible for climate change than your average Ugandan, just in terms of how many tons of carbon we send into the air on an individual basis. So I'm curious how the argument works in that case.
Yeah. So Greenwatch is our partner in Uganda. And that case, it is a public trust case. The plaintiffs and their families have been harmed by the floods. You know, there have been significant floods, climate-caused floods in Uganda. And the issue there is, in part, it's adaptation. It's how do you help support the people in Uganda around all the climate harm that's happening. And in part, it is about what are you going to do with energy, and what kind of energy is going to be the future of Uganda. So I think even in countries that have not been industrialized, like the United States has been, do not have our wealth and infrastructure, there are still choices to be made about what kind of energy investments are made in the future. And citizens around the world are really wanting their governments to plan when they're looking at providing energy services to more people and allowing more people to have more access to a better standard of living. They want them to be doing it with energy that's not going to cause further harm to their people. So I think there's still an element of planning that needs to be done, even by governments with far fewer resources than the United States. And another issue in many countries, including like in South America, it is about also protecting the sequestration capacity of the lands and the forests, which is the other half of the mitigation effort, is to protect those resources. So they are not as responsible, and they will not have as much to do as we do, but they still have a role to play. I think every country on the planet does.
Fantastic. I have one more question then, which is about Greta. Thunberg. Oh, and then there's a very long question that just came in, but to what extent did the publicity around her work, her very powerful, right, chastising the world's leadership about inaction affect your work? Did it, how did it affect your work at all?
I think Greta has really used momentum that was building with youth around the world. I know Greta was inspired by Shatescott, for example, and she was seeing what some youth were doing, and then she stepped up and really caught the eye of the media and world leaders. I actually just watched the I Am Greta film the other night. And she's such a lovable human, right, for everything that she has done. And I think it's helped mobilize more young people who maybe weren't in the streets already, and has fired up the climate movement. I think that's been one of her greatest gifts, is really firing up young people who weren't already engaged and capturing the attention of the media. And so that media spotlight is really important on the movement. I also think it's hard on one young girl to hold so much. And, when I watched the film, I was like, shame on all these world leaders for bringing her in and holding her up and taking photo selfies and then not doing anything. I think it's a powerful story, Greta's story, and it's also a sad story.
So Mona El Kafif has quite a long comment question. And so I'll just actually go to the question and then I know you can see the rest. But so first of all, thank you, Julia, for your hard work and for sharing your stories. What is your thought on movements like Fridays for Future? And then she talks about Greta, chose to strike as this was something that nobody can take from us no matter how old we are. I often thought that we adults should strike as well. We should stop participating in cycles of consumption that are clear, as it is clear that the increase of human population coupled with the same level of consumption, specifically in the Western world, is not sustainable. And so she's referring broadly to all sorts of consumption, of course, including land consumption. So curious about your idea about, should we go on strike?
Yeah, I mean, I think more adults need to do a lot. I mean, I think everyone should be thinking about what is the most powerful way I can step up. And if that's being in the streets with the youth, then get out in the streets, right, and strike. But if it's doing something else because you hold a position of power or influence, then do that. But really, like, we can't put the weight of this on young people. I did a podcast this morning and I was asked at the end, what would the young people ask of us? What would they want us to do? And they would want everyone to get up and do whatever they could to stop this crisis. And they would not want us as adults to put the young people on pedestals like people have with Greta. They would not want us to say that you are our hope and I think everything's going to be okay because the young people are rising up. You know, they want us beside them. They don't want us telling them what to do, but they want us right there beside them, walking with them and struggling with them on this journey. And more adults need to get in the game and start doing that.
All right, well, we have our marching orders, literally, get in the game, march with people, demand change. I'd like to put out a last call for any last questions for Julia and in regards to her really inspiring and far-reaching work. Well, if there aren't any more, we're going to let you go home early, or you're at home, but see your family. We want to say thank you so much for giving us the time, the energy, inspiration. I think we all leave, yeah, it's a serious task and we leave inspired, and hopefully we can rise to the demands that youth are making of all of us as youth and as adults. And I appreciate you really being with us.